Welcome to Employment Law This Week. I'm George Whipple. In today's show, we take a look at the legal implications of an intriguing trend in the field of human resources, big data and people analytics. These tools can assist employers in analyzing large data sets to help with hiring, recruitment, measuring productivity, evaluating fitness for promotion, and more. Frank Morris has seen data analytics emerge as an increasingly important area of his practice.
Businesses are using people analytics today to get away from what they've done in the past, just using headhunters, posting to job boards, seeking resumes, putting ads both online and in hard copy papers, to get a broader net and to get a broader net of folks brought in who are going to be able to do the work that now needs to be done in an increasingly tight labor market and to be diverse and inclusive at the same time. So it really marks a change in the way the net is being cast, as well as some of the indicia that are supposedly being tested through the use of people analytics.
The opportunity to increase efficiency, reduce cost, and improve decision-making is huge. The vast majority of U.S. employers consider people analytics important, and investors see the market potential. In recent years, billions of dollars have been invested backing companies making applications using this technology. But Deloitte's HR consulting branch reports that in early 2016, only 8% of companies were actually using predictive analytics. One reason that employers have been slow to deploy the technology is that it carries its own risks of legal exposure. Nathaniel Glasser recently collaborated with Frank Morris on an article looking at the legal implications of this technology. We asked him about the risks.
The expectation with using people analytics is often that you'll reduce subjectivity and therefore decrease the risk of an intentional discrimination claim. Companies have to be careful that the algorithm that they use doesn't perpetuate biases or otherwise increase the risk of a disparate impact claim. Companies also must be aware of the record-keeping rules that apply to them. For instance, federal contractors have to be aware of the Internet Applicant Rule and how people analytics and the tools that they use might interact with that rule.
It's not just employers that are taking an increasing interest in this area. Regulators and the plaintiff's bar are paying close attention as well.
Employers have to be aware that the plaintiff's bar, the EEOC, U.S. Department of Labor, Office of Federal Contract Compliance Programs, or others may be very interested in potential challenges to employers who are using people analytics. And the reason for that is essentially these are going to be situations where a class action is going to be likely to be appropriate because you have large numbers of individuals who are being screened.
Risk mitigation has to start early in the process, and that means working closer with your data scientists or third-party vendor to ensure that the algorithm doesn't have biases baked in. And it means that you want to work with those individuals to make sure that there's some sort of job analysis that's done to make sure that the algorithm is as business-related as possible.
Get an appropriate clause that provides indemnification or make-whole relief, as sometimes recalled, so that if the employer should be successfully sued because they have used a particular people analytics program, that the ultimate liability would be borne by the vendor who provided that program.
And it doesn't stop there. Employers should be monitoring the algorithm every time it's being used and conduct adverse impact analysis, for instance, when a hiring or promotional decision is being made.
To quote the Federal Trade Commission, the challenge for companies is not whether they should use big data, but how companies can use big data in a way that benefits themselves and society while minimizing ethical and legal risks. We've touched on a few key areas to keep in mind. You can learn more from Frank and Nathaniel's article, linked to in this video. And we'll certainly follow the legal and regulatory standards in this area here on the show as they evolve. That's it for a special episode of Employment Law This Week. Thank you very much for watching, and we'll see you next time.